On the record, in the matter of the people of the state of Michigan versus Cody Clower, file number 23-01846FY, council appearance.
Jeff Broadouts on behalf of the people, Your Honor.
And good morning, Your Honor. May it please the court, Nathan Collison on behalf of Mr. Clower.
Mr. Clower, we need your fingerprints, and I don't know if we advised you of that last week.
I went and did them at
They
the
were
police
completed
station.
yesterday? Yes. Okay, it does look like they were completed. Okay, today's the date and the time that was set for a probable cause conference. Last week, we addressed the timeline, and that's because there's an effort to have a global resolution between this and his matters pending in East Lansing. Is that accurate?
Yes, Your Honor.
Okay, how are we proceeding?
Yes, Your Honor. At this time, the people have made an offer for that global resolution. However, I believe, at least based on our system, Mr. Clower does not have counsel yet for those misdemeanor matters or the misdemeanor matter, I believe, in East Lansing. And I have extended that to Mr. Collison. So I'm not sure how he wants to proceed at this moment. I would leave it.
Mr. Collison?
Thank you, Your Honor. That's correct. I did receive the offer from the prosecutor's office. At this time, we're scheduled for a preliminary examination, I believe, on the 27th. I have relayed the offer to my client. I believe he has to take some time to consider his options, and as was previously stated, he still needs to, my understanding, he still needs to acquire counsel on those other matters, and I will be advising him regarding that. So I think at this time it's probably best just to excuse me, Judge, just to leave that prelim on the calendar for the 27th, and hopefully by the time that date approaches, we can have sorted out some of these issues and potentially have reached resolution, Judge.
Did you say that he had a prelim set in East Lansing as well?
No, on this case, I believe it's scheduled for the 27th.
That is scheduled on the 27th. When is his next court date in East Lansing?
I believe, Your Honor, the pretrial, if I remember correctly from our system, is set for, I think, the 19th in East Lansing.
Okay, well, we will continue to the date of the preliminary examination. We'll treat it as another PCC, so no witnesses will be required to appear.
Thank you, Judge.
No problem. Do you have any questions today, Mr. Clower?
I do not, Your Honor.
Any additional matters for the record, counsel?
Nothing from the people, Your Honor.
Nothing on behalf of Mr. Clower.
Thank you. You're all set, sir.
Thank you, Judge.
Thank you, Your Honor.
Mr. Abbott, did we see Mr. Hayward today? He's here.
He's here.
Okay. Sounds
He's
good.
going to be entering a plea.
Okay. Are we ready on Mr. Johnson?
Yes.
Yeah, Your Honor, thank you. May approach.
Amen. Okay, we're on the record in the matter of the people of the state of Michigan versus Michael Johnson. File number is 23-01872FY. Appearances for the record.
Thank you, Your Honor. Good morning. Ailish Gallagher on behalf of the people.
Good morning, Your Honor. John Abbott representing Michael Johnson today. Mr. Johnson is seated to my right.
Okay, how are you, Mr. Johnson?
Good.
Okay, today is the date and the time that was set for preliminary examination. However, I am told that the defendant would like the court to accept a circuit court plea today. Is that accurate?
Yes, Your Honor.
So that means that the plea would be entered and accepted in this court, but the case will then be assigned to the circuit court for sentencing. Do you consent to that?
Yes, Your Honor, thank you.
Yes, Your Honor.
Okay, can you say that so that we can hear it?
Yes, sir.
Okay, thank you. So you understand, sir, that you have the right in the district court to first have a preliminary examination because you're being charged with a felony in this matter?
Yes, sir.
Okay, you understand that the purpose of the preliminary examination is to require the prosecution to meet their burden, which is to establish that they have sufficient probable cause that a crime was committed and probable cause sufficient to charge you with the crime. You understand that? Okay, and you wish to unconditionally waive your examination?
Yes.
Okay, so that means there won't be a preliminary examination held on the felony matters in this file. You recognize that?
Yes, sir.
Anybody threatening you to get you to waive your exam?
No.
Any promises being made to you in exchange for you waiving your exam?
No.
And you're waiving your examination freely and voluntarily?
Yes, sir.
Okay, so I'll bind the matter over to the jurisdiction of the circuit court at this time. And so now that the matter has been bound over to the circuit court, but the formal information will not be filed until later. The plea today will be on the reading of the complaint or the complaint as amended, but I don't believe we're amending the complaint, correct?
Not amending, Your Honor, yes.
Okay. You waive the right to have the information provided to you today as long as it substantially complies with the reading of the charges here today.
Yes, sir.
Okay. What counts will the defendant be pleading to today?
Thank you, Your Honor. Count 1, 4, and 6.
Okay. Do you waive the reading of counts 1, 4, and 6, sir?
Your Honor, I
I'm
believe
sorry, of the remaining counts that you're not. So are you waiving the reading of counts 2, 3, and 5,
7, Your Honor.
and 7? Okay, very good. Okay, can you read the charges to the defendant?
Thank you, Your Honor. The people of the state of Michigan versus Michael Johnson, State of Michigan, County of Bingham. The complaining witness says that on or about June 8th, 2023 at 540 West Willow, apartment D22, City of Lansing, AM County, Michigan, the defendant did, contrary to law, in count 1, assault with the intent to do great bodily harm less than murder or by strangulation, did make an assault upon Elisa Johnson by strangulation or suffocation, contrary to Michigan law. This is a felony of up to 10 years or $5,000 fine. DNA may be taken upon arrest. A consecutive sentence may be imposed under Michigan law if the assault was committed in a place of confinement. Further, the defendant in count 4 did make an assault or assault and battery upon Elisa Johnson, an individual whom he had a dating relationship. Contrary to Michigan law, there's a restitution notice that if this offense results in damage to another individual's property or physical injury or death of another individual, restitution would be due. This is usually a misdemeanor of 93 days. However, take notice this is the second offense. Take notice the defendant was previously convicted of assaulting or assaulting, battering his former spouse, an individual with whom he had a dating relationship, an individual with whom he had a child in common, or a resident or former resident of his household, or knowingly assaulting an individual by violating Michigan law on April 13th of 2023. Therefore, upon conviction, he will be subject to an enhanced sentence under Michigan law, MCL 750.813. This is a misdemeanor of up to 1 year and or $1,000 fine. A consecutive sentence may be imposed under Michigan law. The assault was committed in place of confinement. Further, in count 6, the defendant did make an assault or assault and battery upon the following person: Kimberly Sabsky. Contrary to Michigan law, there's a restitution notice that if this offense resulted in damage to another individual's property or physical injury or death to another individual, this is a misdemeanor of up to 93 days and or $500 fine. Consecutive sentencing may be imposed under Michigan law if the assault was committed in a place of confinement. The court shall order law enforcement to collect DNA profile identification profiling sample before sentencing or disposition if not taken at arrest. And this was done against the peace and dignity of the state of Michigan.
Thank you. Mr. Johnson, can you raise your right hand? You solemnly swear or affirm the testimony you're about to give is the truth and the whole truth under penalty of perjury. Put your hand down. Count 1 is assault with intent to do great bodily harm less than murder or by strangulation. Do you understand the charge that was read? Okay. And the maximum penalty, sir?
Yes, sir.
Count 4 is domestic violence, but there is a second offense notice enhancing the penalty Do you understand the charge and the maximum penalty in count 4?
Yes,
Okay, and then count 6 is assault and battery. Do you understand the charge and the maximum penalty there?
yes,
Okay, so you have the following rights as it relates to these charges. You have the right to proceed to a trial, and you have the right to a jury trial. At the time of trial, you have the right to the presumption of innocence. So you're innocent until proven guilty. You have the right to require the prosecution to prove your guilt at trial by proving each element of the charges being brought against you beyond a reasonable doubt. Do you understand those rights?
yes.
Okay, and do you wish to give up those rights today? No? Did he do a device of rights at all?
Yes, Your Honor. Should
He
be.
did.
in your
Yes.
gift.
Oh, it is in there. Okay, very good. So you wish to give up those rights today, sir? So that means you're gonna give up the right to cross-examine or confront any of the witnesses in court that the prosecution intends to call against you. You're gonna give up the right to call your own witnesses or present evidence at a trial that you believe further defenses to the charges being brought against you. You're also gonna give up the right to remain silent and not have silence be used against you. Do you understand that? And you wanna waive those rights today?
Yes,
And this is your signature here?
yes,
You read this document? You understand the rights listed here?
yes.
Any questions about these rights? Would you like to plead to these charges? Is he pleading guilty or no contest? He's pleading no contest, and what is the purpose of the no contest?
Civil liability.
That's correct, Your Honor, and stipulated to by the people.
So there is a killer brew in this, is that correct?
There is, Your Honor, there's a Killebrew that pursuant to People versus Killebrew, the defendant would spend no more than 120 days of upfront jail at time of sentencing. Further, there's a Killebrew that the crime victim rights would attach to all 4 victims originally charged, and that restitution, if any, would be determined at sentencing on all counts originally charged. And then the people would request that the no contest on all 4 victims that were originally charged remain in place.
Mr. Johnson, you understand that a killer brew agreement is an agreement about how you will be sentenced, but that agreement is between you and the prosecutor only. You understand that? That means I'm not a party to that. So that means neither are the judges over at circuit court. They're not a party to that. So at the time of sentencing, they could deviate from your sentence agreement. You understand that? If they did do that, you would then have the opportunity to withdraw your plea. You understand that? Okay. Maximum penalty in count 1 is a felony, 10 years or $5,000 in fines. Your DNA is to be taken upon arrest, and a consecutive sentence may be imposed under the law if the assault was committed in a place of confinement. Count 4 domestic violence with a second offense notice makes the maximum penalty 1 year and or $1,000 in fines. Again, a consecutive sentence may be imposed under the law if the assault was committed in a place of confinement. Count 6, assault and battery, is a misdemeanor. Maximum penalty 93 days in jail and or $500 in fines. Again, a consecutive sentence may be imposed under the law if the assault was committed in a place of confinement. You understand the maximum penalty in each of those, correct?
Yes, sir.
Okay. Are you currently on probation or on parole?
I believe.
You say you believe?
Yeah.
You don't know? Is he on probation?
I believe he is, Your Honor. The right to get the judge.
Yes, probation. Apparently you're on probation with me.
Yeah.
Oh, pardon me, with you.
Sounds good. Have you ever been convicted of a felony, or if you have ever been convicted of a felony in the past, you could be subject to the penalties as a habitual offender. Do you understand that as well?
Yes, sir.
And do you understand and give up all the rights that we previously discussed in order to plead no contest today?
Yes.
You also give up the right to claim that your plea was the result of promises or threats that were not disclosed here on the record today? Okay, so no one's threatening or making any promises to you? And do you understand that any appeal of your conviction and sentence would not be automatic, but you would have to ask for permission to appeal your conviction to the Court of Appeals? You recognize that?
Yes.
Okay. We've already stated the agreements that were part of this plea. Any additional agreements that we missed?
No, Your Honor, that's a complete and full agreement, and I believe that, the people upon enter of the plea would dismiss counts 2, 3, 5, and 7.
Mr. Abbott?
Thank you. Based on my reading of correspondence between Ms. Gallagher and your Etheridge, it's a correct description of the agreement.
Okay,
That's
so,
what Mr. Johnson understands as well.
okay, Mr. Johnson, you understand as well, correct? Okay, you would like to enter a no contest plea as to counts 1, 4, and 6, correct?
Yes.
I have your police report for case number 2351905-362. Authored by Officer Christopher Mosby. Incident having occurred on June 8th, 2023 at approximately 1500 hours. Incident occurring at 540 West Willow Street, apartment D22, City of Lansing, Ingham County, State of Michigan. The allegation is that Alyssa Johnson and Michael Johnson, having been in a dating relationship for about 6 months, Alyssa stated to the officer that when he, and she's referring to Mr. Johnson, usually hits her, it's with his right hand. Then Michael Johnson took her phone and began choking her with the phone between his hands and pushed up against her throat. Michael was using both hands to choke her. The victim, Alyssa, did not lose consciousness during this, but was in a lot of pain. But Michael caught up to Alyssa. He pushed her against one of the parking structures in the complex. Michael then ran out of the apartment complex, and Alyssa waited for the police to arrive. The victim, Alyssa, sustained lacerations to her chin and lip during this incident. Also from the same report, from June 8, 2023 at 0030 hours, officers dispatched again to the same address, which is 540 West Willow, apartment D22. Officers spoke with victim Kimberly Sobleski, who had minor injuries. Kimberly stated that she was at home when Alyssa, who also lives there, tried to kick Michael Johnson out of the apartment. Kimberly advised she does not know Michael very well, but knows he and Alyssa dated for some time. Kimberly advised Alyssa told Michael to leave and he refused. Kimberly advised Michael then punched her in the face and head approximately 6 times. Kimberly advised that the police were called and Michael left. Believe that satisfies the factual basis for counts 1, 4, and 6. That accurate?
Yes, Your Honor, I just don't know if we put on the record, me and Mr. Abbott did stipulate to that report being used for the factual basis, and I believe would stipulate to it being included in the record just for purposes of plea, so that circuit court can have it at time of sentencing.
That's correct.
Okay,
Thank you, Your Honor.
thank you. And Mr. Abbott, that satisfies factual basis for the purposes of the defense as well.
Yes.
I will accept your no contest plea. I find the reason for the no contest plea as to civil liability to be appropriate. Also find your plea to be made inaccurate voluntarily and understandingly. So your plea is accepted. This case is transferred to Judge James Jamo for sentencing on September 20th, 2023, under the circuit court number 23-000535 FHC 30.
Your Honor, is there a time given for that sentence?
Yes, it's gonna be at 9:15 in the morning.
Thank you.
No problem. I will also order the transcript of the plea to be transmitted to the circuit court for the sentencing judge prior to the sentencing date. As stipulated, this police report will be incorporated as part of the court file for the circuit court judge to have at the time of sentencing. Any additional matters?
Your Honor, people would just request that if the court wouldn't mind, reminding the defendant that the no contact would be in place for all 4 victims, and that any kind of violation of a court order post plea and prior to sentencing could be depending a revocation of the caliber. Can I have a copy of the names of the 4 victims, if that would help?
It should be stated here in PA 53. Okay, so Mr. Johnson, there was a no contact order put in place by Judge Buchanan back on June 24th for the protection of the 4 victims. That's Alyssa Johnson, Rihanna Lang, Kimberly Sobleski, and a Christina Sager. You're not to have contact directly or indirectly with any of those victims. You're not to cause third-party contact on any of those victims. You're not to harass, intimidate, beat, molest, stalk, wound, threaten, or engage in any conduct that will place any of them or their children in fear, unreasonable fear of bodily injury. You're not to be within 2,000 feet of any of them. You understand that?
Yes.
And you're not to be at the address of 540 West Willow.
Yes.
I think if you postpone, there is a GPS requirement with victim notification in place. Do you have any questions about the no contact order?
No, Your Honor.
Any additional matters for the rest of today?
Just for the record, Your Honor, I did sign an information, and I will file that in circuit court that computes with what we read today in court. Thank you.
Thank you. Anything from the defense?
Nothing from the defense. Thank you.
You're all set.
Thank you, Your Honor. I appreciate the grace and time that you allowed us.
No problem. Thank you. Just the 2 probation. Oh, we got 2 probation files. Step forward arraignment. Oh, okay. On the record in the matter of the people of the state of Michigan versus Michael Johnson, I have file number 23-00622. Okay. And then Mr. Abbott has another plea.
Let's see how I can check. Thank you.
Thank you.
Let's see. I'll be back. Got a couple more.
Oh, she put it on here.
Move some of these.
I'm sorry.
I have some, I think, that are ready to move if you're ready.
Which ones are those?
I believe we can move Abby, Bisbee's coming up, Larson. And then just waiting on Mr. Abbott after that, Mr. Bisbee.
Bradley, Larson.
Yeah, we can do those right now.
Did Larson get his fingerprints?
Larson, I believe, is going to be a 21-day waiver, and Abby, I believe, is going to be a waiver for preliminary.
On the record, in the matter of the people of the state of Michigan versus David John Larson, file number 23-01841, counsel appearance.
Jeff Broadus on behalf of the people, Your Honor.
Assistant Public Defender Sarah Donnelly on behalf of the defendant, Mr. Larson, who is present and standing to my right.
Mr. Larson, today was the date that was set for preliminary examination. 2 counts of an unveiled lawful imprisonment. And then there was a domestic violence habitual offender or defense notice. How are we proceeding, counsel?
Yes, Your Honor, after conversations with the defense, it is my understanding that the defendant has hired private counsel in this matter, so I believe he'll be waiving his 21-day time.
Who did you hire, sir?
Jamie White,
When did you hire him?
yesterday. He said it. He knows him pretty good, so he said that if you want to call him, you can call him.
No need to make a phone call. He can just file his appearance or substitution of attorney, and then we'll get that in the file. But if you just retained him yesterday. That would explain why we don't have a substitution yet, okay? So because you are scheduled to have your exam today, we need to address the timeline. So you have the right to have preliminary examination within 21 days of your arraignment date. You were arraigned back on June 29th, but because you have new counsel and it'll take time to get the paperwork filed in the court for his substitution of counsel, and then he has to get discovery. Are you willing to waive the 21-day timeline for us to reset your examination for that purpose? Okay. Is anybody threatening you? Somebody's phone on? Okay. Anybody threatening you or making promises to you to get you to waive that timeline?
No.
Okay, we'll reset this as a new probable cause conference and PE preliminary examination. And then Mr. White's law office can request an adjournment or switching of those dates if necessary, okay? Because I don't know what the schedule is at this time.
August 10th and 9:30 for the PCC. And then August 18th and 9 AM for the exam.
Okay, so August 10th at 9:30 will be your new probable cause conference, and your preliminary examination will be August 18th at 9 o'clock in the morning. Do you have any questions for the court at this time, sir? Any additional matters for the record, counsel?
Nothing from the people, Your Honor.
No for defense, thank you.
Bond at 10,000 cash surety with no contact order as to the alleged victim, and a GPS tether will continue. You are on GPS tether, correct? You're all set for today, sir.
Thank you.
You're welcome. On the record in the matter of the people of the state of Michigan versus Merjan Osman Abdi, file number 23-02030. FY counsel appearance.
Jeff Prado, it's on behalf of the people, Your Honor.
Luke Goodrich from the Public Defender's Office, here to represent Mr. Abdi, who is standing to my right.
Today's the date and the time set for a preliminary examination. How are we proceeding?
Yes, Your Honor. After conversations with the defense, I believe the parties have agreed to unconditionally waive their right to hold a preliminary examination today. So with that, people would move that this be bound over to the circuit court as charged in the complaint.
That is correct, Your Honor.
Mr. Abdi, you understand that you have the right to have a preliminary examination here in the district court? Okay, you understand that the purpose of the examination is to require the prosecution to meet their burden, which is to establish they have sufficient probable cause that a crime was committed and probable cause sufficient to charge you with the crime. You understand that? I'm sorry? Okay, do you wish to unconditionally waive your right to examination? Okay, that means there won't be a hearing held here at the district court to establish probable cause. And this matter will proceed to the circuit court for further prosecution, including a pretrial and trial date. You understand that? Anybody threatening you to get you to waive your examination? I can't hear you.
No.
Any promises being made to you in exchange for you waiving your exam?
No.
You're waiving it freely and voluntarily?
No.
You understand the unconditional waiver of the exam is that you can't come back later and change your mind. So once it's waived, it's gone. You recognize that? I can't hear you. requiring a waiver to be freely and voluntarily made. The matter is bound over to the circuit court for a bind over date of July 26th. You do not need to appear in circuit court on July 26th, okay, sir? That's the date they'll get the file from the district court. Your next court date in circuit court will be a pretrial. Mr. Goodrich will be made aware of that date. Stay in contact with him, okay? Do you have a phone?
Not.
If your address, contact information changes, you need to make sure the court and your attorney is made aware of that immediately, okay? A bond was set at 3,000 personal recognizance with a curfew 10 p.m. to 7 a.m. unless working. Defendant must reside with his mother. That bond will continue. Any additional matters for the record?
Nothing from the people, Your Honor.
Nothing from the defense, Your Honor.
You're all set, sir. Thank you. What's this?
Mr. Bisbee, Demond Bisbee.
On the record in the matter of the people of the state of Michigan versus Demond Rashad Bisbee, file number 23-00863FY. Counsel appearance.
Jeff Braddock on behalf of the people, Your Honor.
And Luke Goodrich from the Public Defender's Office, filling in for Derek Etheridge today and representing Mr. Bisbee, who's standing to my right.
Okay, Mr. Bisbee, today was the date set for preliminary examination. Counsel, how are we proceeding?
Yes, Your Honor, at this time, I believe the defendant will be waiving his 21-day requirement. It came to, I guess, the party's attention, I think last week, but that Mr. Bisbee has a couple of other files, I believe at least one misdemeanor and one felony file that are before Judge Ward in this court. So in order to sort of meet those files up and facilitate a global resolution, hopefully to those files, I believe the defendant will be waiving his 21-day timeline at this time.
Your Honor, I would also add to that, I was brought to my attention by Mr. Brodowitz that one of their officers was here today and one of them was not available until August 3rd. So, and we would rather run the exam as one hearing as opposed to breaking it half on this.
I would rather run it as one exam too.
Yes.
Okay, sounds good. Mr. Bisbee, you understand that you have the right to have a preliminary examination within 21 days of your arraignment?
Yes, Your Honor.
Okay, your arraignment was on June 29th. However, due to the circumstances of the parties looking for a global resolution and the inability to run one exam today with not all the witnesses being present, are you willing to waive the 21-day timeline so that we can reset this for a new date?
Yes, Your Honor.
Anybody forcing you or threatening you to waive
No, no.
those timelines? Okay, we'll get you a new date.
August 10th at 10:30.
August 10th at 10:30 is your new preliminary examination date. You have any questions today, sir?
No, Your Honor.
What's it being held on?
Your Honor, he has a separate file with Judge Ward right now that has a preliminary exam scheduled next week on an aggravated stalking case. We would ask the court to just keep the PR bond in this file in place while he is potentially considering posting that bond or seeing what happens at the conclusion of the preliminary exam next week.
Oh, he's been in custody, I guess, since the time of his arraignment on here. He's not accruing any time. Recognize that?
I did talk to him about that.
Okay, sounds good. Bond will continue. Any additional matters for the record?
Nothing from the people, Your Honor.
No, Your Honor.
You're all set, sir. Running Wallace
Yes.
and
Yes. Yeah, I think the state law.
So let's get the trash down, Mr. Braddock, Your Honor.
thank you. Let me do this warrant. Who is this, Mr. Abbott? I'm sorry, it's not Mr. Abbott, that's why. It's Mr. Silverthorne.
Morning, Your Honor.
Good morning. What happened to our night at 8:30?
That just said right out. So I'm sure
The 8:30 is supposed to be, but I think Abbott is down in one exam.
Oh, 8:30 is in good place. And let's, they said they're running. So this is Wallace.
Yes, sir.
The record in the matter, the people of the state of Michigan versus Michael Wallace, file number 23-01930FY. Council appearance.
Good morning, Your Honor. Arlene Cisneros on behalf of the people.
Good morning, Your Honor. Dwayne Silverland from the Office of Public Defender on behalf of Michael Wallace, who is, well, he's standing counsel table with my right.
Thank you. Today's the date and the time that's set for preliminary examination. Are we ready to proceed?
Yes, Your Honor. It's my understanding that the defendant wishes to proceed with his preliminary exam today, and the people are prepared.
That is correct, Your Honor.
Any preliminary matter?
Your Honor, just two minor ones. The people will have 3 photograph exhibits. Those have already been marked by Your Honor's staff. It's my understanding that Mr. Silverthorne is stipulating to the admission of those.
Is that correct, Mr. Silverthorne?
That's correct.
Additionally, Your Honor, the last preliminary matter is the people did file a motion for special arrangements to have the courtroom closed due to the victim being a minor in this case. I have kind of changed up my strategy a little bit and will not be calling the minor as a witness, so that will not be applicable anymore. I just wanted to let the court know that.
Okay, I can see the motion for special arrangements here in the file. Mr. Silverthorne.
I think there should be a sequestration order for the witnesses, although I don't see anybody in here, but the house should not. I think there's 2 lay witnesses, Crystal Shutt and Angela Akins, and they should be instructed or informed that they should not be talking to each other.
Sequestration is granted. Any additional preliminary matters?
Nothing from the people, Your Honor.
Anything else from the defendant?
You can call your first witness.
None of the people would call Crystal Shutt. Oh, you can serve, right?
You raise your right hand. You solemnly swear or affirm the testimony you're going to give us the truth and the whole truth under penalty of perjury. Yes. Thank you. You can have a seat. There's a microphone that's in front of you, and behind you is my court reporter. She has to take down everything being stated here today. So your responses must be verbal. They must be loud and clear. We can't do head nods, head shakes, or mm-hs and uh-hs, because we can't write that into the record, okay? Also, if you can keep your voice up loud, I am running the fan because it gets a little warm, and then this sometimes blocks the sound, okay? If there's an objection by either of the attorneys, you would stop speaking immediately. I'll make a ruling on the objection. I'll tell you if you can give that response or not, okay? Please state your first and last name and spell both of them.
Crystal Shutt, KRYSTALSCHUTT.
You could proceed, counsel.
Thank you, Your Honor. Crystal, do you know a Michael Wallace?
Yes,
How do you know him?
we have a child together.
And what is that child's name?
Samantha Wallace.
Do you have just one child in common with her?
Yes,
Do you see Mr. Michael Wallace in the courtroom today?
I do.
Can you please describe what item of clothing he's wearing and where he is seated for the record?
Sitting to the left of me, and he's in a blue jumpsuit.
Your Honor, I'd ask that the record reflect the witness have identified the defendant as Mr. Wallace.
Please stipulate, Your Honor.
Identification is moved.
Thank you, Your Honor. Crystal, when were you in a relationship with Mr. Wallace?
Before my daughter was born.
And how old is that daughter?
She will be 8 in November.
Is it fair to say that you have been out of a relationship with him on an intimate level for over 8 years?
7 for sure, yes.
Do you still keep in contact with Mr. Wallace?
Yes, for the most part.
Mr. Wallace see your guys' child?
Yes.
Do you know if Mr. Wallace has any other children that are not yours?
He has other children, yes,
Have you met them?
some of them.
Did there ever come a time in the first week of May, May 7th, that you had contact with Mr. Wallace?
Yes, he called me on, I believe it was a Sunday.
Does May 7th sound?
It's May 7th, May 8th, it's right there on the weekend. I was at a baptism from Grand Rapids.
And that was of this year?
Is that a yes?
Yes, I'm sorry.
And why did he call you?
He called me to tell me that CJ was missing. They had been looking for him for hours. He had gotten into Roberta's truck and shot off her gun and had scared grandma, and nobody had been able to find him.
Who is CJ?
CJ is one of Michael's children.
And again, that is not your child, correct?
Not my child, no. They just share Michael,
And is that then your daughter Samantha's half brother?
one of her brothers, yes.
What does CJ stand for?
Christopher James.
Christopher James? And is his last name Wallace as well?
Yes.
When you got that call, what, if anything, did you do next?
He had asked me if I was out and driving around, if I had seen CJ, if I would pick him up and bring him home. With that being said, we literally had just made it back into town. I was probably in Lansing maybe 15 minutes before he called me, and we were actually headed to my house. My daughter was in the back seat and heard me talking to Michael and stated that, Mommy, I know where the park is that CJ hangs out. I can't tell you how to get there, but if you get me to Daddy's, I can show you. So I proceeded down Aurelius and drove past Michael's house. She had me turn left on the first street, and she literally directed me left, right through the neighborhood over to Foster Park, which I would think is maybe like 6 blocks from Michael's house. I'm not sure. As soon as I pulled up, Christopher was sitting on the swing. I put my window down, called him. He came right to the truck.
When you kept saying we,
Me and Samantha, I'm sorry.
and again, Samantha is your daughter,
Samantha is my daughter.
and
Yes.
how old is she?
She is 7, will be 8 in November.
Okay, so she was 7 at that time,
Yes,
and her and CJ or Christopher are half siblings.
correct.
Were you able to, I'll strike that question. What did you do next after you found CJ?
I called him over to the truck, and he got in the truck. Once he got into the truck, I had called Michael and told him that I had found CJ to meet me back at his house, and that's what we had done.
Did you, are you familiar with the defendant's address?
Yes, I used to live in the house,
What address is that?
515 South Clement.
You said 515, and is that in the city of Lansing?
Yes, it is.
And did you, in fact, you, Samantha, and CJ all ride together back to Michael's house?
Yes.
Did you exit the vehicle?
I exited the vehicle and went inside to use the restroom. As I had already spoke to Michael, so I knew he was on the way back to the house.
When you went into the home, did anybody else go with you into the home?
Samantha went into the home with me, and Roberta was already in the house.
Did CJ go back in the home as well?
He did go into the home.
Tell me what, if anything, happened next.
I heard Michael pull up on a motorcycle, and I was in the bathroom just about to be on my way out, and by the time I made it out, they were already on the bed.
Tell me a little bit more about what, if anything, you observed about the bed when you came out of the bathroom.
When I came out of the bathroom, Michael was above CJ. The bed is kind of at an angle off the wall, and they were up in the corner. I went around the bed and tried to get Michael off of CJ.
When you said you first came out of the bathroom and you said, I saw Michael above CJ, what do you mean by above?
CJ is laying backwards on the bed, and Michael is hovered over him.
Okay, so CJ's on his back
Yes.
and Michael is over top of him?
Right.
Okay. After you attempted to pull Michael off of CJ, what, if anything, happened next?
Well, the first time I tried to get him off, and because of the way they were at an angle on the bed, I was at an angle on him as well, and he literally was able just to lift his arm, which kind of bounced me off the bed and I hit the floor. I got back up and continued to try to get Michael off of CJ and was able to get him separated. And that is when Michael headed towards the back of the house, which I don't know what he went back there for, but I followed him. And when he turned around, he ended up knocking me down because I was so close to him. And that was how Kristen was able to leave the house.
So I just want to pick apart a little bit of what you said. When you attempted to pull Michael off of CJ, how did you attempt to do that?
I was trying to grab his arm.
His arm?
Mhm.
And where was his arm when you were trying to grab it off?
His neck,
Whose neck?
CJ's neck.
Was, if you recall, was his hand open?
It was open. Christopher was able to talk. He was not gasping for air by any means. They were having words. They were arguing the whole entire time. Michael was saying stuff, CJ was saying stuff, and my whole brain size was just to try to get them separated.
When you attempted the first time to get Michael's hand off, were you successful?
No, because I was being, I don't want to say elbowed, but I mean, he literally just lifted his arm, which took me off the bed.
And I'm gonna get really specific. Again, if you recall, did the elbow hit you with the same arm that he had around CJ's neck?
No.
No. Okay. So he was able to maintain a position on CJ's neck and kind of shove you off. At some point, were you able to pull or get Michael to,
Yeah, I
Let
saw
go.
they got separated.
because you tried again?
I was trying again, and I don't know if it was me trying or the fact that he was going towards the back of the house for whatever he was going back up, for the reason it got separated, but like I said, I was just trying to get him separated.
And I want to be clear that you said that when you first got to the home, you immediately went to use the restroom, correct?
Yes, I had to do it.
And when you came out, you don't know how they got in that position, but you observed Michael on top.
When I came out of the bathroom, they were already on the bed. I heard them yelling. I mean, this was a matter of seconds from the time he pulled up until the time I was done. Like I was literally pulling my dress back down and rinsing my hands and running out the house or running down the hallway. Because I heard them arguing. At that point in time, with me hearing them arguing, I had no idea that they were on the bed until I came out of that.
So the first thing that you observed when you exited the bathroom was Michael on top of CJ in the
Yes.
position you described. And the last time that you saw Christopher in that home, you saw him run out the front door.
In the home, yes. He ran out the front door when we were in the kitchen.
I have nothing further on.
Cross exam.
How's your relationship with Michael?
For the most part, we're better separate than together.
Have you seen him interact with Chris during the years that you've known him?
Yes and no. I really only see Michael at family events or if my daughter is over there. So yes, at a family party on a different event or just being on a weekend, that would be a no.
You ever seen him physically strike Chris before this?
No.
When you got called on the 7th, did Mr. Wallace seem upset?
Yeah.
Did he seem concerned?
Yes,
Did he seem angry when he called you?
he didn't seem angry when he called me at all. I think the anger came once he got into the house and saw Christopher, and I couldn't hear exactly the words that were being exchanged in the bathroom. I could hear them talking to each other, but I couldn't make out what Chris was exactly saying to him at that point in time.
No, you were interviewed by the police after this, is that correct?
Multiple times.
Okay. And is it possible you told the police that you saw Crystal try to swing at Michael first?
Chris did swing at Michael when he was on the bed.
Okay, so you saw him swing at Michael when he was on the bed,
Mhm.
but they
Is
had
that a
been
yes?
already,
Is that a yes?
Yes, I'm sorry.
but they were already on the bed, is that correct?
Correct.
Whatever preceded that, you didn't see?
Stated that.
Whatever came before that, you
No,
didn't see?
I was in the bathroom.
And then you said that you tried to get Chris off, or Michael off Chris, is that correct?
Correct.
Okay. Did he have his hands around? Did you see if he had if Michael had his hand or hands?
He had his left hand on his throat.
Okay. Okay. And what was he doing with his other hand? What was
Well,
Michael doing with his other hand?
For the most part, it was over here, and they were just talking, but I don't know. This all happened in such a matter of seconds that I can't say that I saw him hit him in the head, because my thoughts and my process wasn't watching what this hand was doing. I was more worried about this hand on CJ.
Okay. You said this all happened, sounds like it happened very quickly.
It did happen very quickly.
Could you estimate from the time that you came out of the bathroom and first saw them to the time that Chris left? How much time might have elapsed?
Probably no more than 5 minutes.
And did you say that they were talking?
I could hear them saying something when I was in the bathroom, but the way the house is set up, when you enter the house, you're literally walking into the living room, you go through the kitchen, you have the bathroom to the side and the bedroom ahead of that. And when you're in the bathroom with the door closed, you can hear sounds, but I couldn't make out words.
When you came back out and saw Michael on top of Chris, were they talking at that time? Could you
Michael
tell?
was mostly talking.
Okay, was Chris able to respond?
Yes.
Okay. Did Michael have his hand on Chris's throat continuously?
I can't say yes and I can't say no, because parts of that, I'm behind him. I can't see everything. I do know at one point in time, he had his shirt, because Chris's shirt was twisted and crinkled, like somebody had grabbed it and twisted it.
When you were on your first attempt to separate them, where were you in relationship to Michael and Chris?
Relationship, standing behind Michael.
You're behind Michael? Okay.
And
so
kind of leaning on the bed, I guess.
if you could explain, how did you try to get Michael off?
I was trying to pull his arm to pull him back away from Christopher.
So were you pulling the same arm that you said
The right arm.
pushed you off?
Mhm.
Did he say anything
Yes,
to
I'm
you
sorry.
at the time?
Pardon me?
Did Michael say anything to you
He
at the
wasn't
time?
talking to me at all. It's like I wasn't even there.
Okay. So your description of it is he's basically brushed
He is
backwards.
zoned right in on CJ. And literally, I was just a curtain that was blowing towards him. And I mean, he literally just lifted his arm and took me right off the edge of the bed.
Okay. And how shortly after that did you resume? Because you said
I
you
got
tried
right back up.
Okay. And did you again try to separate them?
Yes, I did.
And was that second attempt successful?
Yes, that's how Michael ended up towards the back of the house and CJ was able to get out of the house.
What did you do specifically on the second attempt?
I just kept pulling at him like I was doing before.
Okay. Well, Michael, when you came out of the bathroom and saw Michael on top of Chris, was Chris struggling?
No,
Okay. What was Chris doing?
laying there,
Okay, he wasn't doing-
listening to Michael yell at him.
Okay. Did you see Chris try to punch Michael at all?
He did try to swing one time.
Okay. You ever see Michael lift Chris off the bed or lift Chris by his neck at any time?
No, not lift him.
Okay. Did you ever see Michael throw Chris against the wall?
No.
When you were in the bathroom, did you ever hear anything like someone was being thrown
No,
against the
I could
wall?
hear words, but I didn't, there was no thumps, no clumps, no loud noises.
And again, in this home, how close is that bathroom to the area that Chris and Michael were?
Maybe the length of this courtroom.
Okay,
From, this is the front of the house and this is the back of the house. The living room is probably level with this. You walk through a small kitchen space and the bathroom's right here.
when Chris left the house, did you see any marks on his neck?
I wasn't concentrated on looking at what was around his neck. I was more concerned about where he was running to and what he was gonna try to do next.
So it would be fair to say is you didn't see, but nothing stood out to you. You don't recall.
No,
anything
he
at
had a
this point.
shirt on at that point in time. I didn't see anything or any pictures of his neck until they were sent to me The second day, I think that he was in the hospital.
When you got Michael off, Chris, were you able to restrain Michael?
No,
Okay. Did he seek to go after Chris at this point?
we both went out the door. I jumped in my truck and Michael jumped on the bike.
Redirect?
Your Honor, just briefly. Ma'am, you had stated on cross-examination that you were most worried about Michael's one hand. And why was that?
With his one hand, his left hand was on his throat. The way they were on the bed, there was no way for me to get to the left side.
When you had told defense that it didn't appear to you that when CJ was laying on the bed, it didn't appear that he was struggling. That's what you said, correct?
No, I mean, you could see he was moving his eyes back and forth. He wasn't red in the face. He wasn't gasping for air.
And I just want to follow up on that. Again, that's all considering that you don't know what, because you weren't out there, you don't know what was happening when we're in the bathroom.
I don't know what happened before I come out of the bathroom.
And when we say he didn't have any, in your view, he didn't appear to be struggling, and you mean physically in that point, correct?
Correct.
I have nothing further for this witness, Your Honor. I'd ask that she be excused.
Thank you. You've excused. You can call your next witness.
I think, Your Honor, the people would call Angela Akins.
You raise your right hand. Your other hand. You solemnly swear or affirm the testimony you're going to give is the truth and the whole truth under penalty of perjury. Thank you. You can have a seat. There's a microphone that's in front of you. The lady behind you is my court reporter. She has to take down everything stated here today. When you said yes, it was very soft. So I need you to use, thank you, a much louder voice so we can pick it up on the microphone. Also, all of your responses must be verbal, so head nods and head shakes and uh-huhs, they won't be accurately reflected. So we need you to say yes or no. Otherwise, you'll hear me ask you, is that a yes or a no, okay?
Yes.
If there's an objection from either attorney, stop responding. I'll give a ruling on the objection, then I'll tell you if you can give that answer, okay?
Yes.
State your first and last name, spell both of them.
Angela, Angela, Akins, Aikens.
You can proceed, counsel.
Thank you, Your Honor. Angela, do you know a Michael Wallace?
Yes, I do.
And how do you know him?
He's the father of my children,
And what are your children's names that you have in common with him?
Daniel Wallace and Christopher Wallace.
Does your son Christopher go by any other nickname?
Chris or CJ?
Is CJ in reference to his middle name, Christopher James?
Yes.
How old as of today is CJ?
14.
And when did he turn 14?
March 2nd of 2009.
So would he still have been 14 then on May 7th of 2023?
Yes.
How long have you been out of a relationship with CJ's father, Mr. Wallace?
13 years.
Taking you back to the time frame of May 7th of 2023, was Christopher or CJ living primarily with you or Michael or both?
He was primary with both. He would go between the two houses, but majority of his belongings were at his father's house.
And at that time, is it true that you had full legal and physical custody?
Yes.
But was it cordial between you and Chris's father, Michael?
Yes.
There became a time where he started to stay at Mr. Wallace's home more than yours.
Yes, June of 2022. We agreed that separating the boys would be for their best interest because they had a lot of altercations and we destroyed my home.
And when you say the boys, you mean your two children in
Daniel and
common?
Christopher Wallace, yes.
Daniel stayed with you
Yes.
in June of 2022, and
Yes.
CJ went primarily to Michael's home.
Yes,
Do you know where Michael lives?
yes.
What is that address?
I don't know the address, but he does live above the bridge from my mother's house. He lives on South Clemens.
Does 515 South Clemens sound familiar?
Yes.
And that's in Lansing, correct?
Yes.
Was there a time on May 7th of 2023 that you were contacted by law enforcement?
Yes.
And without saying what they said to you, what was the reason that they were contacting you?
My son jumped off the building.
Had you had contact with Michael prior to hearing from police?
Yes,
And why did he contact you?
because my son ran away.
And Michael had called you and told you that?
Yes.
When did you learn that he had been found?
Approximately, I do believe it was 10:15 that night.
And who told you that he was found?
Lansing Fire Department.
So just to be clear, you learned that CJ, your guys' son, was missing because Michael called you and told you.
Yes.
And then you did not know that he was found until you had heard from Lansing Fire Department on that same day.
Well, not necessarily. Michael called me and told me that his ex-girlfriend Crystal had brought him back to the home and that he took off. And then we proceeded to look for him as a unit. And then went home approximately 10:15. I got a phone call from the paramedics. Okay.
So let me unwrap that a little bit. So you had become aware that CJ had ran away,
Yes,
was found, and ran away again.
yes.
And at that point, you had not been contacted again until it was by the fire department.
Michael, his mother, his girlfriend, Roberta, and his ex-girlfriend, Crystal, and we all met up, and my husband all met up at Quality Dairy with the police department after we had been out looking for him.
And when did you learn that he was found by Lansing Fire Department?
About 10:15, they called me.
Was that within hours of when he had ran away again?
Yes. We were all at Quality Dairy approximately about 8:30 that night.
When you got a call from Lansing Fire Department, where were you?
At home.
Based off of what they told you in that call, what did you do next?
Called Michael and told him to get to the hospital.
What did you do?
I tried to find a ride home because my husband had already left home.
Did there become a time where you also went to the hospital?
Yes,
And why did you go there?
because they told me my son was extremely hurt and I needed to get to the hospital.
When you went to the hospital, did you have a chance to see your son, CJ?
I did.
Did you meet with law enforcement before that?
We met at Quality Dairy.
Did you meet with them again at Sparrow before you saw CJ?
No.
Did you meet with any medical staff at Sparrow before you saw
No.
CJ?
No, they took me straight into the room.
And without saying anything with respect to what he may or may not have said to you, can you describe what, if anything, you observed when you walked into the room?
He kind of moved his legs.
Was he in hospital clothing?
No. He had cut his pants off him, but.
Were you able to see his face and body clearly?
Yes.
Did anything catch your attention at that time?
No.
At some point, did you go back to the waiting room?
Yes, when they took him back for x-rays.
And did you stay at Sparrow that night?
Yes.
Did you have contact with a medical professional by the name of Emily Morgan?
I couldn't tell you any of their names, to be honest, but I
Fair.
met with multiple nurses and doctors and city nurses.
Fair. I will rephrase that. Did there become a time where you were asked to review and eventually sign a consent form?
I was asked to sign a consent form for x-rays of his throat.
And I'm sure you understandably had a lot going on that night. Did you have to sign more than one form, or do you recall if it was just one?
It might have been two, but I do believe it was one.
Did there become a time, and it may have been on the same form or not, that you gave your consent on behalf of Christopher for the medical team to photograph and forensically examine Christopher?
Yes.
And you signed off on all of
Yes.
this? Were you ever able to take Christopher home that day?
No.
I have nothing further at this time.
Have you always had joint physical and legal custody?
Yes.
By joint physical custody means that he stays primarily with you, is that correct?
Yes.
Has he been able to visit his father during the period of his life?
Yes.
Okay, have you always lived in the Lansing area?
Yes.
And as far as you know, has Mr. Wallace lived in
Yes.
Lansing area? And had you ever had any problems with physical violence between Mr. Wallace and your son before, with
No.
your son CJ?
No.
I'm a little confused. How many times were you contacted by Mr. Wallace? Because it appears that you were called by Mr. Wallace when he first couldn't find CJ earlier in the day, is that correct?
Yes.
Okay, and then later you learned that CJ had been found but left the residence, Ms. Wallace, is that correct?
Yes.
And were you then recontacted again by Mr. Wallace?
I was contacted by Mr. Wallace 3 times. First time to tell me that Christopher was gone. Second time to tell me that he had broken into his girlfriend's vehicle and stole his girlfriend's gun and discharged it multiple times. And then the third time to let me know that he had ran away from the home.
Okay, and then you said we all got together to try to search for him.
Yes.
Was that related to the final time that Chris had left the residence?
Yes.
Okay, and that's when you met up at Quality Dairy at
Yes.
around 8:15. Is that correct?
Yes.
And I take it at that time you were not able to find Christopher?
No.
Okay, but you were later contacted a few hours later by
Yes.
Lansing Fire Department. And as to whatever happened between Christopher and his father, while on the occasion that Christopher was brought back to Mr. Wallace's home, you have no knowledge of that.
I was never informed until Christopher told me at the hospital that his dad put his hands on me.
Okay. But what I meant is you were informed that it occurred, but you didn't have any personal knowledge in that you didn't witness anything.
No.
And you had never witnessed Mr. Wallace
No.
be physically violent before?
No, not towards his children.
Thank you.
I have nothing further, Your Honor. I'd ask that this witness be excused.
Okay, I'm gonna advise you first if there is a sequestration order, so you're not to discuss any portions of your testimony with any other witnesses, okay?
Thank you.
Call your next witness.
Your Honor, the people would call Emily, Mieley Morgan.
Raise your right hand. Do you solemnly swear or affirm the testimony you're going to give us the truth and the whole truth under penalty of perjury? You can have a seat. There's a microphone that's in front of you, and behind you is my court recorder. She has to take down everything being stated here today, so all of your responses must be verbal. It should be loud and clear, audible responses like yes and no or uh-huhs won't work, okay? And then also head nods and head shakes will not work. If there's an objection by either of the attorneys, you would stop giving response. I'll give you ruling as to whether or not you can give that response or not, okay? Please state your first and last name and spell both of them.
Emily Morgan,
Spell them both.
EMILEY
You can proceed, Sandy.
Thank you, Your Honor. Do you prefer if I call you Miss Morgan or Emily?
Both are fine.
Okay. Ma'am, where are you employed?
Squirrel Hospital,
And how long have you been employed there?
since 2010.
And what is your current occupation within there?
I'm a forensic nurse examiner.
And have you been a forensic nurse examiner during your time at Sparrow?
Since March of 2021.
What was your job prior to 21 at Sparrow?
I was a registered nurse in the emergency department for 2 years before that, and prior to that, I was a paramedic in the emergency department.
So paramedic, followed by registered nurse, followed by a forensic nurse examiner.
Correct.
And your current role with that within Sparrow is that of a forensic nurse examiner.
That's correct.
Can you please tell the court what your certifications include and what sort of training you've had that has been required for your job?
So to be a forensic nurse at Sparrow, you have to be a registered nurse licensed in the state of Michigan. And then you also have to complete an orientation, which includes a 40-hour SANE course for adults and a 40-hour SANE course for adolescent or for pediatric. That's through the International Association of Forensic Nurses. I also completed a 20-hour course for intimate partner violence, which included strangulation training, and also for pediatric strangulation training. Besides that, we also do a 1 month where we complete those and observe more experienced forensic nurse, and then a month where we perform the exams observed by the forensic nurse. After completing that, I've also completed multiple other courses through the International Association of Forensic Nurses and through the Prosecuting Attorney Association of Michigan, as well as local agencies with pediatric abuse specialists. I'm also currently completing my master's degree at Texas A&M for my master's degree in forensic nursing about 1 year into that.
Okay. All of those accomplishments and certifications and trainings, did you complete, other than the one that you're going through right now, did you have to complete those prior to 2021?
No. So I started my training when I got my role as a forensic nurse. And then after the 2 months orientation, I worked from home.
Were you required to complete the 2 40-hour segments prior to your prior to taking clients?
Yes.
And you said that was one in adult, SANE and pediatric.
Correct.
And what does SANE stand for?
Sexual assault nurse examiner.
And that you also are certified in adult strangulation as well as pediatric?
And the identification of injuries for domestic violence.
Is included within that?
Including child abuse.
Okay.
All those sources.
What is a typical, if there is one, shift that you work at Sparrow?
I work a night shift, 12-hour shifts, 3 days a week, and then somebody on call if there's a need.
What is that 12-hour block?
7 p.m. to 7 p.m.
Were you working within that capacity on or about the night of May 7th of 2023?
Yes.
Just taking one step back, how does it work? Or can you please describe the scenario of how you get involved with a patient at Sparrow?
So the forensic nurses at Sparrow respond to any patient that is reporting or suspected of experiencing interpersonal violence that includes sexual assault, domestic violence, child abuse, elder abuse, and strangulation. So if a patient is suspected to report staff and nurse or doctor caring for them would page me and ask me to do a consultation.
And you said that includes both suspected abuse on a wide spectrum and reported abuse. I know that seems like 2 obvious words, but what is the difference?
So suspected, an example of suspected abuse would be a child that has an injury where the story doesn't make sense, or a child that's too young to speak for themselves, and the doctor has a suspicion, or a parent might bring in a child that has some bruising and you're suspecting the other parent of abuse. Reported would be if the child or the adult patient tell us themselves that something's happening.
And within your medical duties and trainings, you respond to both.
Correct.
And have you responded to both?
Yes.
And does that range from any sort of injury, whether it's visible or not? And regardless of the extent of that injury? It could be something that somebody would consider minor or very lethal. Did there become a time in the evening or night of May 7th of 2023 that you were requested to report to a patient room? That being a minor? Do you recall that patient's name?
Christopher Wallace.
And if you recall, how old was that patient at that time?
14 years old.
Do you recall whether or not that was due to reported abuse or suspected abuse?
Reported abuse.
What, if anything, did you do prior to making contact with him?
So anytime that we meet with a child or a minor patient, we have to talk to a parent or legal guardian first. Christopher was in Afghanistan and I talked to his mother and explained my role in our services, and she gave written and verbal consent for him to be seen for medical forensic exam.
I know it's not normal to talk louder, but
Sorry.
given the fans and stuff, I'm just gonna ask you to bring your voice a little bit just so the court reporter can get it. So after you got that verbal and written consent from Christopher's mom, did you make actual contact with Christopher?
Yes.
And what, if anything, did that include?
So we had mom step out of the room, and I spoke with Christopher privately. I explained my role and services to him. He gave assent for the exam, and then I obtained the medical history for him for the purposes of diagnosis and treatment, which included his medical and assault history. And then I performed a physical exam where I documented any injuries that I noted during the exam on the body diagram, and also with documentation.
Prior to starting your actual exam, did you have it? You said you had a chance to assess the patient.
Correct.
Was he, by your standards, oriented to time and place and awareness?
Yes.
What is the first step in the examination that you did with him?
To obtain a medical history.
After that, what did you do?
Then I would do a physical exam where I look him over head to toe for injury.
During that medical history examination, was anything brought to your attention about the events of that day?
Christopher reported to me that his father had strangled him and also punched him several times.
What, if anything, did you do with that information?
I completed a strangulation assessment, which is an additional assessment that we complete for strangulation. That includes more questions about the strangulation to find out exactly what happened. And then
What, if anything, if you recall, did you note during your strangulation assessment through the checklist?
Is it okay if I refer to the document?
Would that help?
It would.
Yes.
I just want to make sure that.
Do
you have to use my own copy, or do you want?
Does the court have a problem with that, or would the court like me to approach?
Any objection from the defense if she uses her own copy?
No, that's fine.
You could just look at that and then look up at me when you're done.
Christopher told me that while he was being strangled, he was unable to breathe, unable to speak, and had difficulty containing swallowing.
Thank you. Did your assessment include asking Christopher whether or not Father was saying anything during this?
Yes.
I'll just have you look at it and then you can look up at me so you're not reading from it.
Christopher stated, "Who do you think you are?" Or Christopher stated, his father said, "Who do you think you are?" over and over.
I probably won't need you to review that anymore, but you can keep it, flip over for now. Did you have a conversation about why Christopher was in the hospital?
Yes.
And what, if anything, did he tell you?
He told me that he had attempted to kill himself by shooting himself, but didn't actually hit his head. And then he went to a park, was brought back by Crystal, I believe she's dad's girlfriend or the father of another child. And then got into the football altercation with dad where he was strangled and then ran away again and then went to the Lugnuts Stadium and jumped from a building to attempt to kill himself.
You said what?
I'm sorry. Then went to the Lugnuts Stadium and jumped from approximately 10 to 20 feet to attempt to kill himself again.
When you moved, did you then move on to your physical assessment? And does that always include head to toe,
Yes.
regardless of where the suspected or reported injuries are? And did you complete a head to toe examination?
Yes, I did.
Before we get into the head and neck area, were his injuries with his legs consistent with what he had reported to you?
Yes.
Regarding his jump or fall? What, if anything, do you do during your exam overall for physical?
I inspect the area with the skin or the mucous membranes, and then I also palpate to see if there's any pain with palpation.
And what is another word for palpate?
Touch.
Did you examine his upper body, specifically his neck and head that day?
Yes, I did.
What, if anything, did your assessment reveal?
He had bruising with the TPI on his anterior and lateral neck. And he also had bruising behind his ear with the TPI and bruising along the top of his ear.
Was that all?
He also had redness under his eye where he said that his father had punched him.
And was that all visible to you?
Yes.
Did you use the word petechia? What is petechia?
It's a type of bruising that looks like pinpoint red spots that's caused from blood vessels breaking from pressure built up.
Is that a medical term?
Yes.
Did you complete the diagram that is consistent when you assess an individual for strangulation? What, if anything, do you do next in that sort of scenario?
After I completed my exam and then I would go document all that information on our medical forensic chart. I also contacted police and law enforcement, police and CPS as part of kind of our follow-up.
Based off of, in this specific case, what you saw and heard from CJ, as well as what you discovered in your assessment, what, if anything, did you do next with regards to your tracking of his injuries?
Besides documentation.
That's okay. Does documenting include photographing?
Yes.
Does it always in every case?
As long as there's a visible injury and they assent to it, I do document every injury.
Based off of your findings with this patient, did you take photographs?
Yes.
And did you take those photographs simultaneous to or right after your report or assessment?
I do it during the physical assessment. So as I go head to toe, I will take pictures of an injury and then I'll ask the patient, do you know how this injury occurred?
And did you do that in this case?
I did.
And were those pictures taken with a department issued device?
Yes.
And was that a handheld camera?
Yes, it's a digital, right.
Did you have a chance to save those to your file?
Yes.
And were those shared eventually with law enforcement as well as child protective services?
Yes, we released them to law enforcement.
If you saw those, would you recognize those again? May I approach, Your Honor?
No.
I'm going to hand you 3 photographs, Ms. Morgan. They've already been marked and admitted to by stipulation by the judge. If you don't mind looking through these people's exhibits 1 through 3, you can look them at as a group or hold them up, whatever you're comfortable with. If you could please confirm that those are the photographs that you took, as well as the injuries that were consistent with what you saw that day.
They are the photographs that I took, and they are consistent with the injuries that I saw.
If you could please, either as a whole or one by one, go through and reference some of those medical terms with a visual.
So
You can hold it up towards the judge. If you
this photograph shows the bruising on Christopher's neck and also the petechiae throughout. This photograph also shows.
What exhibit number was that?
Pardon?
The first exhibit that you just described, what exhibit was that?
That
What
was one.
exhibit number?
Oh,
That's
okay,
exhibit
sorry.
number 1?
Exhibit
Okay.
1.
I'm sorry.
The second photograph is exhibit 2. It also shows the bruising throughout the lateral and anterior neck, and also bruising on the side of the lateral neck on the right.
Okay.
And then exhibit 3, this photograph shows bruising along the top of the ear and also bruising behind the ear with petechiae.
Thank you.
Thank you. When you do your assessment, do you reach a finding or is it case by case basis?
It's a case by case basis.
Did you have a medical opinion or finding in this matter?
I felt that the injuries that I observed on Christopher were consistent with the history that he provided.
And you have testified that you have handled strangulation cases before, not only in training, but also as a forensic nurse examiner at Sparrow. Were the pictures that you just showed the court, as well as what you observed that day, consistent with what you would see in a strangulation situation?
Yes.
Have you had contact with patients that have had self-inflicted marks on their neck?
Ligature marks or manual strangulation. I've only seen it with ligature marks, not manual strangulation, which would be the hands.
Can you describe what ligature marks would look like if they would differ?
Ligature marks usually have a defined, like, linear line that you would see from like a rope or an electric cord or like a rolled up blanket, something like that. Where manual strangulation would be from the hands, it would be more like either patterned from fingerprints or more dispersed, just from that general pressure.
Based off of your medical training and what you observed that day, would you classify this as ligature?
No.
No, I have nothing further this time.
Cross-examine.
Had you ever seen Christopher before this evening?
Okay.
Before the evening of the 7th, had you ever seen Christopher before?
No.
Did you have any idea as to what his reputation for truthfulness was or wasn't?
No.
Did you inquire of his mother?
I spoke to his mother briefly about his medical history, and she did say that she didn't know exactly what had happened that night, but there had been some kind of altercation with his father,
Okay.
and that he had attempted suicide.
Oh, he did. Okay. Actually, on 2 occasions that day, is that correct?
That's what Christopher reported to me.
Okay. You said you took his medical history?
Yes.
Okay, would that be because it was happening so quickly of necessity, only an oral history given to the patient?
Generally, if I see a patient on my own, so we do also do outpatient services where someone might just get a medical screening in the ER and then I would see them upstairs. I would document a full medical history. When they're a trauma patient who's being cared for in the ER by a physician, then I would just defer to the medical chart for the ER for a medical history, but I do obtain it from mom and from Christopher to find out if there's anything significant I need to know. sorry.
So that, basically, that's, yes, you just take the oral history from whatever sources you can get, right?
In Christopher's case, I did.
You generally don't get into data banks about any other prior history, correct?
I did do a psychosocial assessment of part of the history of Christopher to ask if he had any history, and also with mom, and they did say they had a history of suicidal thoughts.
Did Chris indicate what had occurred specifically that led up to what he reported to you as the alleged strangulation?
The history that he gave me was that he went to his grandma Sandy's and was with her. She brought him back home. Nobody was home. He attempted to shoot himself, missed, put the gun back, ran to a park. Crystal found him at the park, brought him back home, and then that's when the physical altercation with Dad took place. And then after that, he went to lug nuts.
But you don't have any personal knowledge as to who might have initiated that physical altercation, do you?
I just have what Christopher gave me as history.
Really don't have a lot of questions. No, thank you.
Redirect.
No, Your Honor, I'd ask that this one speak, please.
Okay. There is a sequestration order, so that means that you cannot discuss any portions of your testimony with any other witnesses. Other than that, you may be excused. Call your next witness.
Your Honor, the people's final witness would be Detective Tim Mapley.
Do you solemnly swear or affirm the testimony you're going to give us the truth and the whole truth under penalty of perjury?
I do, Your Honor.
Thank you. You can have a seat. And please state your first and last name and spell both.
My name is Timothy Mapley, Timothy, Mapley, Mapley.
Take a seat.
Your Honor. Where are you employed?
With the Lansing Police Department.
And what is your current role within the Lansing Police Department?
I'm assigned as a detective to the Special Victims Unit.
And how long have you been in that unit?
In Special Victims specifically, it's about 6 months, DB just less than a year.
How long have you been a detective?
Just under a year,
How long have you been a police officer with the Lansing Police Department?
5 years.
Do you have any prior law enforcement experience?
I do.
And how long is that?
13 years total,
13 years
8.5 with another agency.
What, if any, certifications or trainings did you have to go through to be in the role that you're currently in?
In my current role, obviously certified as a police officer, going through the police academy. I've been through interview and interrogation schools, both basic and advanced read schools. I've also been trained as a forensic interviewer.
Now, with the forensic interview training that you went through, is that specific to adult, adolescents, or all the above?
It's specific to children, interviewing children, but as an interview practice, it's widely accepted as a very good practice to interview.
And have you, in your professional capacity, forensically interviewed children and adults as well?
Yes.
Were you working within that detective capacity on or about May 7th of this year?
I was.
Did there become a time on May 8th of 2023 that you were assigned a case?
Yes.
And who assigned you to that case?
It would have been one of the detective bureau sergeants.
And is it fair to say that you were assigned this case given the nature of it?
Yes.
And what was that nature of it? What was the nature of the case?
The nature of the complaint was suspected child abuse.
When you were first assigned to the case, did it have a suspect or defendant name attached to it?
It did.
And what was that name?
Michael Wallace.
And did it have a child?
It did.
And what was that name?
Christopher Wallace.
What, if anything, did you first do when you were assigned the case?
First thing I did was read over the police reports from the road response to the initial incident.
In the initial incident that you're referring to, did that take place on May 7th?
Yes.
So just the day or night prior?
Yes.
What did you do next?
Next, I reviewed body camera. I also reviewed the other attachments to the report.
Did you also have contact with caseworkers from Child Protective Services?
Yes, I did.
And did you also have contact with medical staff from Sparrow Hospital?
Not personal contact, but received reports from.
And is that common practice within your role to review all of that evidence?
It is.
Did you make yourself aware of who the, if any, witnesses were in the case?
Yes.
And did you have a time to find out the age of the minor victim?
Yes.
And how old was he?
14 years old.
And what was his relation to Michael Wallace?
Christopher Wallace was the son of Michael and was living in the house with Michael.
Based off of your initial review of the case, did you learn what the initial call was on May 7th?
Yes.
And what was that for?
It was initially for a runaway complaint.
Did you ever have any contact with the minor?
I did not.
Did you ever have any contact with other witnesses of the case?
I did.
Do you remember any of the names of those people?
Crystal Shutt was one of the witnesses, as well as Roberta. I don't recall her last name. And those were the primary witnesses to the incident.
Did you have contact with the minor's mother as well, Angela?
I did.
Did you have any in-person contact with anyone?
I did, yes.
And who would that have been?
With Mr. Wallace.
And Mr. Wallace is
Michael.
Michael.
Yes,
And do you see Michael in the courtroom today?
I do.
Can you please state one of my clothing and where he's seated for the record?
Yes, he's seated to my 11 o'clock, blue shirt, white undershirt, with a beard.
Thank you, Your Honor. I know it's already been established, but I ask that the record also reflect the detective has accurately identified the defendant.
Again, no objection, Your Honor.
So noted.
Thank you. When did you have contact with him in person?
I don't recall the exact day. I think it may have been on the 16th or 17th.
Of May?
I believe so.
And was that initiated by you or Mr. Wallace?
That was initiated by me.
And again, is that standard practice?
Yes.
What was your, I'll strike that, why did you contact him?
I contacted him for an interview to get his side of the story.
And again, this was in reference to the incident with CJ, his son.
Yes, that's correct.
Did there ever come a time where he did actually come into the apartment and meet with you?
Yes.
Was that interview audio and video recorded?
It was.
Was anyone else present during that interview?
Yes, CPS investigator Jennifer Super was present as well.
And he was not under arrest, free to leave?
Correct.
How would you describe his demeanor with you?
Very calm, professional.
What, if anything, did he state to you about CJ's living arrangements with him?
He advised that CJ had been living with him since the summertime, approximately 2022.
Did there ever come a time where you got into the events or incident from May 7th?
Yes.
What, if anything, did he tell you?
So he told me that it began as he was notified by, I believe it was his mother, that CJ had come over and said something about shooting off a gun. And so he went home to go try to make contact with CJ. And my understanding was that CJ had run away. And so when he went home, that he wasn't there. He told me that he called Crystal, who is CJ's godmother, to try to help him find her, or try to have her help him look for CJ. And that he was notified by Crystal that she had found CJ and was bringing him over. Crystal was bringing CJ to Michael's house.
Did Michael say anything to you about anything that happened after that inside their home?
Yes.
What was that?
So he said that they got into an argument, that he basically was pretty upset with CJ, and that CJ said something about his brother who had died in 2019 that really upset him. He said
I'm
that
sorry, off Michael's brother or CJ?
Michael's brother.
Okay.
And he said that he was pretty upset about it. And he said that at one point, CJ swung at him, tried to punch him. And he said that he grabbed CJ by his shirt and shoulder and shoved him down onto the bed.
Did you have any follow-up questions regarding what he had told you?
Yes.
And what were those?
So my questions were more directed at where did you grab him? Do you remember what parts of his body you grabbed? And he said that he grabbed the front of his shirt and the top of his shoulder and put him onto the bed. He described to me that he had been a bouncer for one of his other jobs, that he got in physical altercations all the time. I asked for clarification on whether CJ had been injured the morning of, if Michael knew CJ to have any bruising or marks earlier that day, and if he knew how CJ had the injuries that he presented at the hospital with. And he said that he did not.
Do you recall if at any point he mentioned Crystal's name?
Yes.
How did he mention her name?
He mentioned that Crystal was there. Obviously, Crystal had brought CJ to the house, and he said that while he was physically grabbing onto CJ, that Crystal tried to intervene.
Did he tell you whether or not at some point he got off of Christopher?
I don't recall the exact words, but yes, that he had put him down onto the bed, and that when Crystal intervened was when CJ got up and ran out of the house again.
At the conclusion of your interview, did Mr. Wallace leave?
Yes.
And at some point, did you have any other contact with him?
Only to notify him about court processing later.
I have nothing further, yeah.
Processing.
I just have a few questions. Did you take any statements from anyone that indicated that Chris did not throw a first punch?
I did not.
So the only statement you got was Mr. Wallace indicating that Chris had swung at him.
That's correct.
And did Mr. Wallace indicate that he potentially pushed or did anything with Crystal?
I don't recall his exact wording. I'd have to watch the video again, but he basically said that she tried to intervene and that he, was dealing with her, and that was when CJ ran out. I don't recall the exact words.
The interview with Mr. Wallace and with all of the witnesses was video and audio tape, correct?
It was.
Would you agree that despite your testimony today, the most accurate and reliable version of any of those statements would be by reviewing that audio videotape?
I would agree.
Okay. I have no further questions.
No,
Your Honor, I asked that Detective be excused.
Detective, there is a sequestration order, so you can't discuss any portions of your testimony with any other witness. You may be excused. Any other witnesses?
No, Your Honor.
Okay, is the defense calling witnesses today?
No, Your Honor.
You can proceed to argument.
Your Honor, may I
Take your time.
hand these exhibits to the court?
Yes. Thank you.
Your Honor, I would ask that the court make a ruling that enough testimony was presented to rise to the level necessary for bind over. The court heard testimony with regards to not only kind of the picture of the minor child between Miss Angela Akins and Chris and Michael Wallace, but also what happened on that day, May 7th of 2023. Unfortunately, or fortunately, Christopher was able to survive the situations that he went through, but the evidence was very clear that, consistent with count 1 and count 2, that he was strangled or suffocated, and that the defendant himself admitted to touching him. It comes down to where and how long and how hard. The evidence is clear, most compelling from the people's position by the medical forensic nurse examiner, as well as Crystal, who is an ex of Mr. Wallace, who does have a daughter in common, who was also present that day, as she testified to the court that she did see Mr. Wallace's left hand in a open fashion around Christopher's neck. And I think she said a few times that that's all she was worried about was getting him off of Christopher. Of course, only Christopher and the defendant know how they got on top of that bed or what was said or done prior to then. But we do have his testimony of Crystal Schutt that when she came out of the bedroom, Mr. Wallace, who is the biological father to Christopher, was on top of Christopher with his hand around his neck. Miss Schutt was attempting to remove Mr. Wallace's hand from the grasp that he had on Christopher and was successful after a second time of doing so, right before Christopher was able to break free and run from the house. Your Honor, the medical testimony today did corroborate that, and so much so, as the court can see through the pictures, that there are evidence not only supported by visual exhibits, but also oral testimony that is consistent with strangulation as ruled by the nurse examiner, as well as other signs that we see that she sees with strangulation. Petechia, which is from pressure and the blockage of blood flow through the caplets within the blood. Additionally, Your Honor, there was further petechia through the back of Christopher's neck, on the front as well as on both sides of the neck. Additionally, Your Honor, the testimony that was supported by all the witnesses was that Christopher was a child that was in the lawful custody or care of Mr. Michael Wallace's father when this occurred, and that the physical harm that was placed on him that day was intentional, or at least knowingly could have created a high risk of physical harm. With that being said, Your Honor, I would ask that the court find that enough evidence exists for the fine over standard and find the matter over to the circuit court on counts 1 and 2, and with count 3 being the misdemeanor, for that to follow. Thank you.
I'm going to pause find over. What we have here is a father who is given custody, effective custody, although not legal, physical, is allowed to stay. His child, Christopher, is allowed to stay with him for the past year because Christopher gets into fights with his brother, apparently to the extent that he can't remain with his mother anymore. We have both the mother and Crystal Schutt who indicate that they've never witnessed any physical violence. What we do know is that when it's reported that Chris has shot a gun to try to kill himself, that this concerns Mr. Wallace, who then enlists Crystal to help find him. She finds him, brings him back. We don't know who threw the first punch. We do know Chris has apparently a propensity to fight, because that's why he's with Mr. Wallace. And again, there's no history between the two of them of physical violence, as reported both by his mother and by Crystal Schutt. It apparently, Mr. Wallace is a very big man, but Crystal, it apparently in a very short order, because she said the whole thing took less than 5 minutes, was able to get him off. We don't know if he was trying to restrain him. I don't think that there's sufficient intent, okay, which is required by the intent to create violence, to strangle him, but perhaps to subdue him. And possibly, I would agree that it's certainly understandable that Ms. Wallace might be very, very upset. Then after Chris leaves again, this man is content, where he now enlists also Crystal and mom and other persons to go out looking for him. So this poses more a situation of a very concerned father regarding a suicidal son. So in terms of count three, which is, or count two, which is count three, which is the domestic violence at Crystal Shut, she says she's not even aware if he was aware of what happened. It was simply an arm motion moving upwards. I don't know that even rises to the level of an assault or assault and battery on Crystal Shut. So I'm asking that the court dismiss all of these charges and not find that even in the lesser burden of just a preponderance of evidence has not been met. It would have been good to have Chris here. He might have shed some light on it. If he's not, that's fine. That he's not. But that being, the case, the court has to take the case as it receives it, and I don't think that the burden's been met. Thank you.
Okay, today was the date and the time set for preliminary examination. The burden is on the prosecution at this time to establish that they have sufficient probable cause that a crime is committed and sufficient probable cause to charge you, Mr. Wallace, with the crime. This is not a trial. They do not need to prove each element beyond a reasonable doubt. The court will be the sole determiner of the credibility of each of the witnesses that were before the court. All we need is more than just mere suspicion that there was a crime committed. And we have here first testimony from Crystal Shutt, who testified that on or about May 7, 2023, which she described to be a Sunday at the area 515 South Clemens, that she received a call from the person she identified as the defendant, Michael Wallace. She said she shares one child in common with Mr. Wallace, that Mr. Wallace contacted. He seemed upset or concerned because this teenage son that they called CJ, also identified as Christopher Wallace, CJ, the J denoting his middle initial, was missing, had run away from home. Ms. Shutt said that she attempted to try to help locate CJ and bring him home, and that she, once in the home, that she had gone to the restroom, and she comes out and she said she observed CJ laying on his back on the bed with Michael hovered over him. She described Michael Wallace's arm to be around or on CJ's neck. And she claimed that the defendant had maintained a position around CJ's neck. She attempted to try to remove him off of CJ, but that resulted in her being shoved off by Mr. Michael Wallace. We've heard testimony also today backing up. Ms. Shutt did describe that during her observation, she did see Christopher Wallace attempt to swing at Michael Wallace, but she did not see what preceded that incident. This was as Michael was already hovered over Christopher Wallace when she observed the attempted swing. She described Michael's left hand on CJ's throat. She did not observe him being CJ gasping for air or appearing to be going on or becoming unconscious. We heard a testimony from Angela Akins, who's the mother of CJ. She reported having gotten notified that CJ had ran away on the date of May 7, 2023. She had contact with the police on that date and time, and that Michael Wallace advised that the son ran away, that he was returned home and then subsequently ran away again. And she later heard around 10:15 from the Lansing fire and or paramedics. And she reported to the hospital. She was advised that CJ was extremely hurt. She said she observed him to be unable to move his legs, and they had to cut his pants off of him while in the hospital. She consented to x-rays and then also gave permission for the medical team to perform a forensic examination. She said that she was told by CJ that his father put his hands on him. We heard testimony from Emily Morgan, who's the forensic nurse examiner, and she indicated that she performed the examination on CJ back in May of 2023, and that CJ reported to her an incident involving being strangled by and punched several times by his father. CJ reported that he was unable to breathe and or speak. That during the alleged incident that Michael stated repeatedly, "Who do you think you are?" Defendant later, after running away multiple times, ended up at the Lugnut Stadium where he attempted to take his life by jumping 10 to 20 feet, causing injury. The defendant had bruising, she stated, around his neck and ear, redness around his eye, consistent, she said, with the injuries that he describes. We have people's exhibits 1, 2, and 3, which this exhibit testified indicates or shows bruising to the neck. She refers to as petechiae, described as the bruising or bursting of blood vessels of some sort due to the pressure buildup. Or People's Exhibit 2 also consistent with the same injuries described, and then People's Exhibit 3 show injury behind the ear to the ear. She being the witness, Emily Morgan, testified that she took these pictures and that the injuries were consistent with what she described as, or what was described by CJ as what happened as relates to being strangled and punched. We also heard testimony today from Detective Timothy Mapley, who reported in response to the incident of suspected child abuse. He stated he made contact with the medical staff and caseworkers. And he reported that he testified that he received a report that the defendant had abused or strangled his son. He said that he spoke directly with the defendant, Mr. Wallace, Michael Wallace, reporting that he only grabbed the son from the front shirt and placed him on the bed, and that he had some prior experience as bound to a security officer, and that in that incident he was attempting to restrain his child, that there was a history of the child being aggressive and or assaultive with another child, that he shared joint custody, physical custody with the child's mother. In count 1, the defendant is charged with assault with intent to do great bodily harm, less than murder, or by strangulation. In order for the people to prove this beyond a reasonable doubt at trial, they would first need to prove that the defendant, that being Mr. Michael Wallace, tried to physically injure another person. Second, that at the time of the assault, the defendant had the ability to cause an injury, or at least believed he had the ability to cause the injury. And third, the defendant intended to cause great bodily harm. Actual injury is not necessary, but if there was an injury, you may consider it as evidence in deciding whether the defendant intended to cause great bodily harm. Great bodily harm means the physical injury that could seriously harm health or function of the body. As charged, it's assault with intent to do great bodily harm, less than murder, or by strangulation, occurring at 515 South Clemens, making venue before this court appropriate. There's been countless testimony by Ms. Shutt, by Ms. Morgan, and then also by Ms. Akins and Detective Mapley, describing an incident occurring on May 7th involving a report of Mr. Wallace strangling CJ, and then his arms were placed around his neck. The defense counsel argues that we do not know, based on the history of this child and allegations that the child has been assaulted or has had a history of fighting other siblings. We don't know whether or not or who threw the first punch or blow. He also argues that we don't know if, in fact, the father was simply restraining his son because his son may have been combative in this time. And I agree, we don't know. And that sounds like it's a question for a jury to determine or the trier of fact. So with that being stated, count 1 is bound over to the circuit court for further prosecution. Count 2, child abuse 3rd degree. In order to prove that at trial, the people will need to prove beyond a reasonable doubt. Did I say 3rd degree or should be child abuse 3rd degree? I don't know what I said. In order to prove that at trial, the people would need to prove first that Michael Wallace is the parent and or guardian of Christopher Wallace. We heard testimony here that he is the father and that he shares custody. That would satisfy the second element, which is that he has care or custody or authority over that child when the abuse allegedly happened. And then second, that the defendant either knowingly or intentionally caused physical injury. I think that's implied by what was described here, which is that Michael Wallace restrained and or had his arm around CJ's neck, or who's positioned over CJ's neck with his left arm, but that he punched CJ multiple times. I think that would demonstrate sufficient probable cause that he either knowingly or intentionally caused physical harm, at least by the punching. Second, that the defendant knowingly or intentionally committed an act that under the circumstances posed an unreasonable risk of harm or injury to CJ, and that the act resulted in physical harm. We have exhibits that demonstrate where the defendant allegedly strangled, causing this bruising around the neck. Even in these, if we took into consideration that there was a possibility that he was restraining CJ, I think that it would be reasonable or unreasonable to restrain him in such a way that you're hovering over his neck, causing bruising to his neck or cutting off his ability to breathe. But then there's also allegation that he was struck in the head multiple times by being punched. So with that being said, the court is satisfied that we have sufficient probable cause as to count 2, child abuse 3rd degree. That will be bound over to the circuit court as well. Count 3 is a misdemeanor. We do not need to address probable cause. That will be bound over to accompany counts 1 and 2. The bind over date is July 26. You do not need to appear in court on July 26. That's the date that the circuit court gets the file from the district court. Your next court date will be a pre-trial in the circuit court. Mr. Silverthorne will be made aware of that date, and he'll be in contact with you, okay?
If I may, I'll wait till you're done writing.
You want to trust bond?
Yes.
Okay, give me just.
He has $100,000 cash surety bond. He has 1 prior conviction for domestic violence in 2012 in Eaton County, so it's 11 years ago. He does have 2 other felony charges pending. He retains the presumption is in that charge. And those charges, just as he has that in this. On those charges, he has faithfully abided by all bond terms on both cases and has appeared for all court proceedings. So he not just has appeared, but he's abided by the bond condition. He has a good job with Pure Green Lawn and Tree Experts as a lawn maintenance technician. He earns $19 per hour. He can retain his job working in the field if it's re-released on tether, which is what he was on his earlier 2 cases. Ultimately, he'd be allowed to do sales work from home if the court wishes to up that a little bit, house arrest with tether. From those wages, he pays child support under 4 different orders for 5 children in the approximate amount of $366 every 2 weeks, which I calculated is just under $800. That's by wage withholding order. That is, of course, stopped since he's been in incarceration, but it would be reenacted if he could be taken. He has support of his fiancee, Roberta Ramirez, who did not appear today, but is also a witness in this case, with whom he's engaged and married on August 18th, at district court. From all of this, I would ask that the court moderate his bond to a degree. I would ask for a $20,000 cash surety. He's going to show up. He did not, in this offense, whatever else you can say about it, he did not initiate the events that began it. The almost fatal behavior of the child trying to take his life is what initiated it. I'm not sure how I would have reacted, particularly if I have a child who has a history of being aggressive and there's an altercation and we lose our temper. I'm not justifying it. I'm simply saying that it doesn't seem to present. The issue is he going to appear? He has a history, an absolute history of it. Does he present a danger to the public? Again, he did not bring or initiate the acts that caused this. So I don't think that he presents a history. In fact, his 2 exes that appeared today, one the mother and one of a child, indicate that there's not a particular violent history towards the children. So for these reasons, not asking for a PR bond because he was out on bond when this occurred, but I'm asking for a moderation of the bond, maybe $20,000 cash surety. Also, he will lose his home. He will lose his home if he can't get back to work. So for those reasons, Your Honor, I ask for some moderation of his bond. Thank you.
Thank you, Your Honor. Understanding that the court did hear a brief bond argument on behalf of the defendant from Mr. Abbott last week, who was covering for Mr. Silverthorne, I would ask that the court deny the defendant's bond modification request, even more so as of today's date, post the evidence that was presented in the testimony, Your Honor. As the court indicated last week, in its ruling to leave the bond as is, this defendant does have and is still on bond, was on bond at the time of the incident that the court just had her testimony in, was on bond in 2 separate circuit court matters, one which has a date of offense of May of 2021, and the other which has a date of offense of April of 2022. Those cases both made it through the district court phase and requirements in our pending trial at the circuit court level. Those cases, one of which includes a criminal sexual conduct in the 1st degree, which, as the court knows, is a life offense. The second case involving strangulation, intimate partner, domestic violence case as well. Those 2 cases involve entirely different victims and entirely different parties. Again, different from this case, which also includes different individuals, different parties. The people are requesting that the court deny the defendant's bond, not only for the defendant's continual interactions with the court system and charged offenses, understanding that he is presumed innocent until proven guilty, but this defendant's, as the people would draw the court's attention to the bond factors and a reason for denying the defendant's motion, primarily being the seriousness of the offense charged and a danger to the community. I understand and would agree with Mr. Silverthorne that Mr. Wallace has been timely, has been present, but my main concern for the protection of the community would be that he is on bond for 3 separate serious violent natured cases, which all involve different individuals that he is the common denominator on. With that being said, Your Honor, and after hearing the testimony of the not only lay witnesses, but medical professionals, given the case as well as the cases that Mr. Wallace is on bond for. Thank you.
Thank you. Looks like bond was set at $100,000 cash surety at the time of arraignment. And the defendant has multiple cases pending at this time in the circuit court, felony cases, that is, I believe. Let's see, he was on bond at the time of the alleged incident. He has one count of criminal sexual crime, first degree pending, another count of assault with great bodily harm and or by strangulation pending, domestic violence second offense pending, another assault, GBH strangulation pending, another felonious assault pending, aggravated domestic violence second offense, an unlawful imprisonment pending, and interfering with electronic communication pending. I can't say with one way or the other because it's a question of fact as to whether or not Mr. Wallace initiated any of the actions that occurred at the date alleged. I only have the evidence which I've seen, which is a substantial bruising shown in the exhibits to the victim's neck, which would support, at least based on the testimony of Miss Morgan, that the defendant strangled the victim at the time of the incident. At least she testifies that these pictures show injuries that are consistent with strangulation. I believe there is a serious threat to the public safety. There's an overwhelming amount of violence alleged and pending before the court. I think that the bond, as said, at 100,000 cash is more than appropriate to secure the protection of the public. I don't dispute. I don't see anything that indicates that Mr. Wallace doesn't appear in court. But the concern in this matter was public safety. And so I think bond is appropriate and will continue as set. Any additional matters for the record?
Nothing for the people, Your Honor. Thank you.
Nothing, thank you, Your Honor.
Thank you. You're all set.
May I approach, Your Honor, for the exhibit?
Yes, please.
Thank you.